gives me great pleasure to introduce Lisa Austin, who's an associate professor of law at the University of Toronto Faculty of Law, where she did her LLB and her PhD in philosophy. She's been teaching that since 2001. Lisa has published numerous articles on privacy, the law of privacy, property theory, and legal theory more generally. So she's going to speak to us today about privacy and power.
Thanks, James, and thanks for inviting me. Thanks for coming today. The paper that I circulated is a draft chapter from my current book project, where I'm writing a book about privacy law. And I thought that I'd start by talking about the book project a little more generally in order to situate the chapter, and then walk through its main line of argument, which is to defend an understanding of privacy, or at least our moral understanding of privacy, as protecting the terms of self-presentation. Okay, so one of my interest in privacy is to understand it in relation to discussions and debates that are going on about the nature of the information society, or the nature of the information state, where contemporary information practices are thought to mark out something new in terms of how we organize, socialize, and govern. And when people express their concerns about these practices, it's the language of privacy that they most often reach for. So privacy has become the site of resistance and contestation in relation to the information state. And one of my questions in my book project is whether privacy can really bear the weight of this. Privacy seems to raise more questions than it solves. It's notoriously difficult to define. Questions arise about whether it's a coherent idea, whether it's a set of multiple related ideas, whether it's a term we just use that actually embraces ideas that would be better to separate out from privacy. There are debates about why we value privacy, how to balance it against other values. And there are debates about whether privacy is too narrow a concept to deal with contemporary issues, whether we need a different set of ideas. One of the frequently raised sets of ideas, for example, in the privacy literature these days, are things like transparency and accountability. And I'll talk a bit more about that as we go. Now, my project is to look at these issues, but really take the perspective of not just privacy, but privacy law, with a real emphasis on the law part, rather than privacy that we only understand primarily in some extra legal, moral, or social sense. And the extra legal moral understanding of privacy is important. It informs law. It also provides us with a standpoint for a critique about the law. But what I want to do in my project is to also focus on law and not just leave it in the background as this kind of set of tools we use to protect and promote these interests that we can understand quite apart from law, which is how privacy gets taken up in quite a lot of the privacy literature, particularly the American privacy literature. Okay, so why this emphasis on law? What I want to argue is that law brings something very special to the table. So one of the claims I'm going to make generally in the project is that law is a very special kind of tool, and one that, among other things, I don't want to say this is the only thing that's interesting about law, but one thing that's important and interesting about law is that it's concerned with power, and that the basic idea behind the rule of law is that the state's exercise of power should be constrained. Many have also argued that this contemplates private, so-called private relations. Things like, property law and contract also have a rule of law context to it, which I agree with, that law concerns itself with power as between individuals as well. And a lot of issues that are being flagged about the information state are about private and public power. And so my claim is that if we foreground law, we can achieve some clarity about that. And if we look at privacy law, again, emphasizing the law and not just continue on many of the discussions about the nature of privacy apart from law, some kind of moral idea of privacy, then I think what we'll also see is that there's lots of ideas of constraining power that are already present in the law of privacy itself. And I keep saying this over and over in different contexts, but one great example, at least in the Canadian context, is the search and seizure context of constitutional law. So this would be like the American Fourth Amendment. In Canada, it's Section 8 of the Charter. which the jurisprudence over and over emphasizes the dangers of broad police discretion as much as it emphasizes anything about the nature of privacy. The model that you see is not about preventing state access to information as if it's going to protect some kind of absolute sense of privacy, but ensuring that access occurs in a manner that's transparent, proportional, and accountable. These happen to be many of the values raised by people in the literature who claim that we need to get beyond privacy, that privacy law is too individualistic, neoliberal, and my response to them is always that privacy law is actually all about this already if we would just see it and see that there's a whole set of interests and values there. So let's not throw the baby out with the bathwater by overemphasizing privacy, not understanding what law is doing in this other set of ideas. It's also important to look at law in order to understand when our supposed extra-legal understanding of privacy is really an understanding of privacy already deeply shaped by legal ideas. That is, if we examine our intuitions, we might find that the law is already there. James Whitman calls this juridified intuitions. And the worry about this is that it can unduly constrain our understanding of privacy, especially if what we're trying to do is to develop sources of critique of new types of practices. So what might I mean by this? For example, tort law, right? As tort law emphasizes a set of ideas such as when is it fair to hold another liable for an injury? Well, there's a framework there of individual responsibility. Some at least would argue, I realize there are multiple different accounts, but some would argue this is premised on, private law ideas of equal agency or some such thing. You have strong emphasis on ideas of harm, causation, individual responsibility. All of that comes from tort law, right? None of those are privacy ideas, that's tort law. But then if you look at the tort of privacy, you can start to see that what you get is a really strong emphasis on things like harms. And the discourse on privacy is incredibly steeped in, well, what's the harm of this particular practice? Where's the injury of this particular practice? Why does that violate somebody's right? Well, all of that's interesting if what you want to do is ascribe responsibility in the kind of tort law sense. But what if you just want to understand, is there a privacy interest of some sort at stake here that we might want to build a new model around? You need to pull those ideas apart. And if you stay within the tort paradigm and you don't see it as a tort paradigm, you see it as a privacy paradigm, you start from a very constrained kind of point of view. Another aspect of privacy that law, I think, brings into focus is the idea of countervailing interests. So privacy law almost always involves balancing the individual's interest in privacy against some other kind of interest. This is what happens in law, right? You have multiple parties and you're trying to accommodate their interests and rights. So state security, law enforcement, business interests, the interest of another individual in being free from unforeseen liability, right? There's all sorts of ways we can construe those other interests. So what you can't do is look at a particular legal outcome, right? What was protected in a particular legal context and say, deduce from that we understand something about what privacy means, unless you separate out whatever that individual interest in privacy was from those countervailing interests. And I say this because there's a lot of popularity in the privacy literature on so-called contextual accounts. So privacy is deeply contextual, it shifts around with different contexts. But what shifts in those contexts is sometimes a privacy interest, and sometimes it's the countervailing interest, the nature of the interest, the strength of the interest. And if you're not attuned to that, then you're going to go off, I think, on your analysis. Okay. And then finally, I think that what I want to do, particularly in this book project, is also look at the broader context of our legal categories in order to see how they fit within sort of broader understandings of law and power. So for example, liberal state of nature stories, and we talked about one of them yesterday at the other session, can be understood as a reaction against some kinds of social hierarchies. So the abstract selves of such tales, right, mark out what's juridically relevant and filter out things like one's status within a social hierarchy. So we get a deep concern for things like abstract equality. You get a particular vision of law. You get property and contract protected by a state. You get a state also concerned for things like criminal law enforcement. But there's a different right, model of the state that emerged last century, the social welfare state. It's a reaction against a different kind of social hierarchy, one based on wealth. You get, and the idea of the state changes. The state takes on a role of active provider of benefits. You get a deep concern for substantive equality. In fact, some of these concerns arise out of a reaction to that previous model of this state. And law changes too, right? And so it's not just a state and an area of law where you have property and contract and the state protecting it, but you also get administrative tribunals and administrative law, and it's a whole massive change in the nature of law. And so part of what I'm looking at in this book is it the case when we talk about the information state, and I'm not sure what the answer to this is, but is it the case that we're actually seeing some really new version of what the state is that's calling for some broader understanding of why law should change in relation to that? And that's important because a lot of our privacy law models come out of these other sort of broad ways of casting what the state is. So we have tort law models of privacy that come out of that sort of classic liberal state. Even search and seizure law, it has such deep roots in notions of trespass that come out from that notion of, you protect the home against state intrusions. Data protection law, modeled on fair information practices, which has become a hugely important area of privacy law, really is at home in that administrative kind of world. It's a concern about bureaucratic decision making and information practices within that kind of administrative state model, and is now sort of migrating to the private sphere as well. So are those ideas of privacy law which take their roots in these kind of other models of the state and other times, are they actually going to be adequate to the concerns that are emerging now if we think that there's something really new at stake? Okay, so that's all the parts about kind of law that much of the rest of the book takes up. The thing is that you can't talk about privacy law only about law. Like, I'm not some kind of strong formalist who thinks that the law is somehow impervious to moral and social concerns. And I think that actually one of the interesting things about thinking about privacy law is that even when one works across all sorts of different legal models, you have, right, classically private law models like tort law, you have data protection law in the private sector, you have data protection law in the public sector, you have constitutional law, you have increasingly international human rights norms. And across all of these different spheres, we still seem to think that it's meaningful to say there's something called privacy that's at stake. Now, there's skeptical challenges to that, but it's incredibly resistant to those skeptical challenges. And I find that fascinating that privacy is so resilient. And so I think there is an extra legal moral understanding of privacy. I think we need to kind of pull it out from these different legal regimes and ask questions about it and think about what work it does do and what its limits are. So that's what I want to talk for the rest of my talk about. What's this extra legal understanding of privacy? And I want to defend the idea that this extra legal understanding of privacy is best understood in terms of self-presentation, which I'll try to explain. Okay. So just as I've been saying that law brings its own kind of shaping influence to what we mean by privacy, when we're talking about privacy law, I think that there are different ways we understand morality that also influence what we mean by privacy when we're trying to just understand this extra legal notion of privacy. And here I find Charles Taylor's views that there are sort of what he calls three axes of morality really, really helpful. So what he refers to in some of his work is that there's these three axes of moral thinking, which he argues are present in every culture, although to varying degrees. So one of them is our sense of respect for and obligations to others. So this is really where the ideas of things like rights and responsibilities are most at home. Another is our sense of what makes a full life. So this is where ideas of human flourishing or perfectionist kinds of moral accounts would be most at home. But the third, which I'm kind of fascinated with at the moment, is what he calls a sense of ourselves as commanding attitudinal respect. And I'll just read a quote from Mrs. Taylor's words. "The issue of what one's dignity consists in is no more avoidable than those of why we ought to respect others' rights or what makes a full life. However much a naturalist philosophy might mislead us into thinking of this as another domain of mere gut reactions, similar to those of baboons establishing their hierarchy. And in this case, its unavoidability ought to be the more obvious, in that our dignity is so much woven into our very comportment. The very way we walk, move, gesture, speak is shaped from the earliest moments by our awareness that we appear before others, that we stand in public space, and that this space is potentially one of respect or contempt, of pride or shame. So this is more of an idea of dignity, but I realize dignity itself means a whole pile of different things. So dignity in the sense of what Charles Taylor says, commanding the attitudinal respect of others. So the moral agent in this space is not determining her ends in life according to an ideal of flourishing, nor is she interacting with others according to some ideal of what we owe to others in those interactions. Instead, this is the space where individuals interact in order to command the respect of others. And these aren't like mutual exclusive categories, right? We can have all of these. Charles Taylor says all of them are present to some extent or are not. And this is what I think privacy in its interpersonal aspects, in this kind of moral sense and interpersonal aspects, is most at home. But I think that a lot of accounts of privacy adopt aspects of this and then feel what I want to call the gravitational pull of these other two aspects, either human flourishing or this sense of obligation, and they kind of mash the ideas together in different kinds of accounts. And what's important, why I like sort of Taylor's taxonomy, is that I think it's helpful to show that this idea of, well, I'll just call privacy as self-presentation, which I'll explain, but it's kind of a privacy as a dignity account, is not a cultural claim. And so James Whitman, American legal scholar, very prominently wrote about the two cultures of privacy, and he says, you know, the Americans have an idea of privacy as freedom, and the Europeans have an idea of privacy as dignity. And they're just really culturally rooted in the different legal cultures. And what I think Taylor's point shows is that, you know, these three moral axes are present in all cultures, but to varying degrees. So it's true that there are different cultural differences as to, you know, how they get expressed, how they get protected, how deeply valued they are or not. But that doesn't mean that there's not some kind of basic idea of privacy as dignity that has a kind of analytic structure that we can kind of pull out from that. And that's what I'm interested in doing. And I also think that it's more complicated than someone like Whitman puts forward, because I think that this, in any given society, particularly he talks about law a lot, so he merges sort of the moral and the legal together quite sort of self-consciously. But the structures that law gives us in any given society can come to protect a multiplicity of interests beyond what seems to be the sort of core idea. So for example, Whitman speaks of the home as part of a paradigmatic view of privacy as liberty, right? So this is not a privacy as dignity account, right? He says, no. This is about privacy as liberty. It's part of private property. It's this important boundary against state interference, which, you know, is true so far as it goes, but property norms also permit the protection of privacy in this totally different sense, even if that's not the intention of having privacy norms, even if that's not their justification. But the fact that we can exclude others from our homes means that we can actually shield our activities from others in different sorts of ways. We can control the audience of our activities in a way that I'm going to argue in a bit is really important. We can put curtains up and we can close them, right? And all of these things are open to us because of the way property norms operated, but they allow us to sort of piggyback on top of that, a protection for privacy in this totally other sense. So I would actually quibble with him and say that even if, right, you have this privacy as liberty being protected in the law, that doesn't mean that those legal structures can't also be protecting privacy as dignity, right? I think it's far more complicated than he makes out. So this dignitary space that Charles Taylor sort of opens up as one axis of moral thinking is the realm of what I think, what sociologist Irving Goffman called self-presentation. So for Goffman, self-presentation is the way we present ourselves to others in order to influence their reaction and treatment of us. It's an intersubjective space, right? It's concerned with our social identity, how we appear to others and how we feel about how we appear to others. And I actually think this is a very good way of thinking about interpersonal privacy. And that privacy norms protect our capacity for self-presentation, and what we flag as a loss of privacy maps onto a failure of self-presentation. And so I just want to walk through a little bit of Goffman's account and indicate why I find it so interesting. So for Goffman, and he uses a lot of language of drama and being on stage, he says that individuals present themselves in social interactions, and the self is the performed character that emerges from this presentation. Okay, so the main concern is that the performance is successful, that it's not disrupted in some way. And what I think he means by disruptions in self-presentation map on a lot to what we mean by losses of privacy. And I say losses of privacy because I think that language of violations of privacy, I want to say, comes from other sorts of ideas. So one of the key ideas that comes out of Goffman is the importance of audience segregation. So he uses the imagery of the theater or putting on a play and talks about the back region, which is at the sort of off-stage area where the performance is constructed, and the front region, which is the stage that has props, it has a team, and there's an audience. And he says, outsiders can disrupt the performance. And it's interesting because for him, outsiders to either of those regions can disrupt the performance. So outsiders to the back region, you can think of the back region as a kind of, one way to get a sense of this, the idea of our home as a back region, a place where, to use T.S. Eliot's, the poet's idea, you put on your face to meet the world. So a lot of people see their home as a kind of place of repose in that way. But for Goffman, it's just important to keep in mind that that back region is not a space of solitude. There's people there. It's just that you want to keep outsiders out of that region. Outsiders to the front region are also a problem. We present ourselves to a particular intended audience, and outsiders can disrupt this as well. So you can sort of relate this to privacy issues in the sort of issue that lots of people like to chew on about, is there privacy in public? And the answer from this kind of Goffman account is yes, because just because you're in public and a certain kind of audience can see you, that's your audience, doesn't mean that suppose you have video cameras that are taping you in public and changing the nature of your observation, changing the nature of the audience, either in space or time, then that could be, right, an outsider that's disrupting that performance. So there's a way of getting at privacy in public. For Goffman, information control is also an issue. If the audience gets access to information that undermines the performance, this disrupts the process of self-presentation. So outsiders and information control, I think the basic issue really at the end of the day there is kind of audience segregation. And a lot of privacy issues are about audience and information in this way. And Goffman's helpful to help you think about this in more fluid terms than some kind of rigid, this is public and this is private. Now, one of the things that I think Goffman also helps explain, just to give kind of explanatory power to it, is if you take a look at just to go back to the law for a minute, tort law, the 4 torts of invasion of privacy are often thought to involve 4 very different ideas. They're separate, nothing unifies them. They're part of, a lot of people like to point to them in skeptical attacks about there being anything unitary about privacy. But all of them actually deal with different aspects of disrupting self-presentation. So publicity given to private facts is one of them. Intrusion upon seclusion is another tort. Both of these, I think, deal with the issues of audience segregation, but in different ways in terms of front region and back region. False light publicity and appropriation of name or likeness are 2 others. These are not about audience segregation, but I think a different kind of disruption. I think the issue in those is the sense in which a particular presentation is self-presentation. So to be portrayed in a false light is like having a performance imputed to you when you were not involved. To have someone appropriate your name is to have them perform as you. Right? So I think that the different branches of the tort address different problems that actually could be united as seeking to protect the basic conditions of self-presentation. with the caveat that then all this tort liability stuff comes in to help shape it as well. Okay, so a few things that are important apart from kind of audience segregation that comes out of Goffman, though, and I think are underappreciated, even from people who like to cite Goffman. This is really an account of social identity, and it's social in a very deep sense. So Goffman's self is not a self that has some kind of pre-social inner core, right? It's a self formed through social interaction. It's not an act of self-creation, but what Goffman calls a collaborative manufacture. So the social self, at least, right, how you appear to others, depends on social structures, on social roles, and on other people. People are part of your team, even on stage, along with the props. And so there's a real strong sense of the importance of social context and social norms and rules that help make any performance credible. And that's really important. But also the idea of the active participation of others, including the active participation of the audience. So the audience participates in the success of the performance, often through what Goffman points to as different forms of tact. And I think norms of tact are really interesting. So an audience might ignore something that might otherwise disrupt a performance, for example. And I think that we often don't understand that technologies, when they disrupt our sort of regular ways of thinking about privacy, whether things are private or not private, we often don't think about that social context and things like social norms of tact. So there's a lot of debates in privacy literature about things like practical obscurity. So an example would be when people are thinking about, well, what's the difference between paper records and electronic records? If paper records at a courthouse, for example, are considered public records, why on earth would there be any privacy issue that would attach to making all of those records electronic and available freely over the internet, for example? They're public records. They were public records when they're paper, they're public records when they're electronic. And the one answer, whether you find it convincing or not, it doesn't matter, but one answer is when they're paper, there's a kind of de facto protection because of something that people like to call practical obscurity. It's just difficult to scrape the information from those records, to compile it in different ways. And because it's difficult and it's expensive and it's time consuming, people won't do it. But once you make them electronic in a centralized database, easily accessible, all sorts of other practices become important. And some people think those raise privacy considerations that at least merit an independent consideration and not just, well, there's still public records. So that's the practical obscurity sort of argument and debate. But what's still missing in all of that is I think new technologies also affect social context in which norms of tact also protect people. And we're not looking at that, and we need to pay attention to that. I just want to kind of show why Goffman is so interesting. I want to contrast just briefly with two kind of very dominant accounts of privacy in at least the privacy literature to show why Goffman is similar in some ways to these accounts, but also quite different, and how these other accounts seem to be much more in the gravitational pull of these other moral axes that I pointed to. So one very prominent definition of privacy is Alan Weston's from his book Privacy and Freedom, and he's been extremely influential in courts as well. The Canadian Supreme Court, for example, loves to cite him. I think it's like the only privacy book they read. But privacy is the claim of individuals, groups, or institutions to determine for themselves when, how, and to what extent information about them is communicated to others. Right? So control over information. This looks a lot like Goffman's concern for audience segregation. And but it's not a very social understanding of identity, which makes it, I think, more limited. And what do I mean by that? Weston's idea of control over information is very bound up with ideas of self-revelation and autonomy, not really how we command the attitudinal respect of others through self-presentation. Self-revelation is more of an idea that we have a self that's formed prior to social interaction, and the individual who possesses this self then decides what to reveal to whom and for whatever reason. And Alan Weston actually had this view of, you have this sort of self that has all these sort of concentric circles. And so you have this, like, the inner self of all your most intimate things, and then, you know, these different circles, and they correspond with, I guess, different levels of intimacy, in a way that I think, you know, made sense at a certain time, and at least my students always tell me they don't see themselves in that account whatsoever. But one consequence of Weston's view and is that he really emphasizes individual control and doesn't seem to at all see the importance of the active role that others play. So just to recall, for Goffman, the audience can save a performance, right? And this has nothing to do with control. So for example, your bag might be open. I might be able to see the contents inside, but I can choose to avert my eyes. If I see it, I can choose to pretend I didn't see what was in front of me, right? These are the norms of tact. This isn't necessarily about protecting your sense of what you want to control. It can be based on my sense of what's appropriate in the context. And so Goffman stressed these ideas of social norms and rules and how they affect audience expectations. And so privacy can be protected in that context, quite apart from any idea of individual control. Another issue that's really difficult to make sense of on control-based accounts is that the idea that it makes sense to say some individuals choose to give up their privacy. As people accuse the young of this all the time, right? They're just choosing to give up their privacy. And the dilemma on a control-based account, just conceptually, is in giving up their privacy, they're in fact controlling the disclosure of information about them in the way that they want, which for Weston is the essence of exercising privacy, not giving it up. Right? So on Weston's account, you can't really say someone's choosing to give up privacy in that way. But if you look at the social dimensions of self-presentation on Goffman's account, you can see that an individual can engage in a performance that does not respect general social expectations regarding audience segregation and information control in that particular setting for that particular performance. So again, because he has this more social sense, you can make sense of someone choosing to give up privacy, why we might label that behavior in that way. So Weston's account gets at some aspects of audience segregation, but seems to be rooted in a different idea of the self, one more at home in a moral axis stressing autonomy, and which, you know, might be why it's so popular in certain legal circles. Okay. The other major definition of privacy, at least amongst, you know, sort of accounts that are trying to come up with some conceptual account of privacy, are the so-called limited access accounts. So Ruth Gaveston was very prominent in this. Anita Allen has defended an account like this as well. And the idea there, in a nutshell, is privacy is a state where others have limited access to you. And in this kind of account, privacy is a state of social withdrawal. So you have perfect privacy when you have perfect solitude, and privacy norms protect our capacity for withdrawal. Now, one of the problems with limited access accounts, I think, is that so many things become a loss of privacy that the real question isn't identifying losses, but figuring out when we should care about losses. Right? 'Cause it's just so easy to identify a loss of privacy. So why do we care? And why do we think social withdrawal is so important? On a lot of these accounts, social withdrawal is seen as important for an understanding of what I want to call self-constitution. So how an individual constitutes the self free of the influence of other people. So it's not a concern for how we command the respect of others, but a concern for self-determination. That what you affirm as your values and interests are truly yours, not simply given to you by others, a kind of concern for authenticity. So the issue is to insulate you from social pressure and conformity. And this too is a kind of self, a sort of liberal view of self that fits more comfortably along the other moral axes than self-presentation. So privacy as limited access is more about insulating individuals from social influence, not on protecting aspects of social interaction. And so they have a kind of different emphasis. Now, I think actually Goffman's account of self-presentation can accept the impulse for social withdrawal, but it just would cast it in very different terms. It would cast it in terms of the ability to withdraw from some kinds of audiences, and maybe the pressures that some kinds of audiences bring to bear, but you're not withdrawing to a space of solitude, right? Because again, for Goffman, there's always people in these different sort of back and front regions. I'm looking for time checking. Okay. So I go through a few other accounts in the paper, but I won't sort of belabor the point now. And I wanted to kind of close by highlighting a few things about this kind of, again, extra-legal account of privacy. Can it help us understand new issues? Is it limited in different sorts of ways? And one of the questions, so again, as I said at the outset, I think there is this idea of privacy, and it's interesting to think what is consistent about our idea of privacy across different contexts, legal contexts in particular, across these different legal models. But at the same time, I have some discomfort with that story. One of the questions I have in my book project is the extent to which this idea of interpersonal privacy as self-presentation, how far it can really go when so many of our privacy issues, I think, aren't really ones of interpersonal relationships. So what do I mean by that? So here's a really simplistic picture, but I think it captures something. So we have interactions, I want to say, you know, these intersubjective relationships within the social sphere. So it would be like us talking together here, not just, you know, I don't mean by this sort of intimate relationships, just interpersonal relationships. But we also have a category that in my book I just designate as information intermediaries. So corporations, right? So these are sort of private sector actors. They're not government institutions. These are like internet companies, for example. They collect your information in various sorts of ways, and we interact with them in various sorts of ways. But I call them intermediaries because what they do is it's not just that it's a corporation and I'm involved in some kind of transaction with this corporation that has these informational dimensions, which doesn't seem to map on to self-presentation and these dignitary interests very well at all, I would say. I might be wrong about that. But also these intermediaries increasingly mediate the relationships within the social sphere, right? So the Facebooks of the world and the Googles of the world and whatnot, they're building communications platforms through which we interact with each other, right? So they play this mediating role in the social sphere. They also mediate increasingly our relationship with the state, right? So not just because the state finds it very convenient to collect information from us, from these intermediaries. There's that, but also there's this phenomena that it occurs in different sorts of ways, but in Canada, the way it seems to be playing out is, you know, you have these contracts that when you sign up for these services, we see this a lot in our internet service providers, and, you know, contractual clause 2942 says we might share your information with the state. And then the courts have been like punting this, and they haven't decided it. They've been sort of getting around it by not having to deal head on with the issue. But some lower courts have said, well, you know, you might have had a reasonable expectation of privacy in some of this information, but look what you signed, right? They told you they're going to share this information, so now you don't have a reasonable expectation of privacy. So some contract of adhesion, you know, somehow then is taken to change the nature of our expectations in relation to the state in a way that's really, I find strange, but it's there, and the courts haven't been undermining that theory with any, they've been avoiding it or saying, yeah, actually that does change your expectation of privacy in relation to the state. So these information intermediaries are doing a lot of really interesting things. And it's not clear to me that, you know, this kind of moral thinking about privacy that's so rooted in this kind of interpersonal relationships is actually the same kind of, that the privacy sort of tracks all of these different issues in any kind of straightforward way. It might be that the issues are a little more orthogonal to that. So you might worry about an information intermediary's information practices. There might be a bunch of reasons about, you know, sort of the fairness of their information practices that have nothing to do with privacy. But you might also care about that they're not sloppy because you worry about information you disclose in one context being used in another context. Again, this issue of audience segregation, getting out into the social sphere where it does affect you in this way that I've been trying to flag. Or you might be concerned about their information practices because they're actually constructing in lots of ways the architecture of that social sphere now, at least in terms of our online interactions. And so that issue of that kind of dignitary space is still there, but not in a straightforward way, and kind of coming at it from a slightly different angle kind of way. So that's one of the things that I'm sort of trying to puzzle out. The thing that, when I think about sort of the big data debates, and I'll just sort of close on this thought, I do actually think self-presentation at least helps us shine the light on a couple interesting aspects of what's going on with big data. Because one of the sets of issues with respect to big data, I think, is what people have been worried about in information communications technology for many, many, many years, which is this disruption of audience segregation. So you collect information when you can store it and when you can, share it easily. The idea that it's going to stay in front of the audience you intended to have it in front of really changes. And that just kind of, with big data, goes on speed. But one of the new issues that comes out with big data is that the use of analytics in relation to the information and the drawing of new inferences about people. So it's not just that you take information from one context and it can now easily move to other sorts of contexts, but there's this massive collection of information, there's analytics being done on the information to draw new sorts of inferences and then action taken on those inferences. And I think that this can actually disrupt self-presentation in an interesting new way, that you no longer present yourselves in a world where you actually understand the social rules and norms that you inhabit, right? So you need to have some understanding and a shared understanding with, sort of your audience, and on Goffman's account, if your self-presentation is to succeed. And what's happening with these sort of, secret processes of information collection and new inferences is that, you're being sorted into categories you don't know. You're being judged against categories you don't know. You don't know how to anticipate how you're going to be seen and dealt with in ways that are very startling to people and difficult to navigate. And so there's a kind of concern there that's not just about a concern for potential harms. I mean, there's lots of discussion about potential harms, although there may be some, or lost access to important life opportunities. This also may be true. But what I wonder about is that whether there's also some other more kind of concern coming that we can flag through using this account of self-presentation or this sort of dignitary account of privacy. And I think that, and the sort of last point of this is, there's a lot of hand-waving around things like big data. I'm just kind of working through a lot of the literature now, so I don't have anything sort of big and profound to say about it. There's a lot of hand-waving and a lot of set of concerns, but it seems to me that, a lot of them start tracking in this very rough way a kind of concern about the loss of dignity issues more generally. And so I find that fascinating because I think that, our kind of moral intuitions about privacy are really more at home with privacy as dignity, as I've been arguing. But I'm not sure that all those concerns that are getting flagged are really privacy issues, but maybe they're pointing to that same moral space as kind of the area of concern. And I think it's one that's not well developed, right? We like to work on more of these ideas of moral obligations or human flourishing, and we don't think much about this other space. And that might be an important place to start looking.